Ladies and gentlemen, this morning I am thankful that the Supreme Court of the United States has saw fit to look out for the safety, rights, and protection of our most vulnerable people. Ladies and gentlemen, this is from Fox News by Ron Blitzer. Supreme Court gun decision shoots down New York rule that set high bar for concealed carry licenses. The Supreme Court ruled in its first major gun case in more than a decade. The Supreme Court Thursday ruled 6-3 that New York's regulations that made it difficult to obtain a license to carry a concealed handgun were unconstitutionally restrictive, and that it should be easier to obtain such a license. The existing standard required an applicant to show proper cause for seeking a license and allowed New York officials to exercise discretion in determining whether a person has shown a good enough reason for needing to carry a firearm, stating that one wish to protect themselves or their property was not enough. Can you imagine that? What's more important than protecting yourself? What's more important than protecting your life? Oh, protecting the lives of athletes and stars and politicians in New York, because they can all get licenses. Their bodyguards can get licenses, but the average person who's being attacked on the subway can't. That's ridiculous. Number one, you shouldn't need a license. In this case, petitioners and respondents agree that ordinary law-abiding citizens have a similar right to carry handguns publicly for their self-defense. We too agree and now hold, consistent with Heller and McDonald, that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. Justice Clarence Thomas wrote in the court's opinion, referencing two previous gun cases. Because the state of New York issues public carry licenses only when an applicant demonstrates a special need for self-defense, we conclude that the state's licensing regime violates the Constitution. It surely does. Thomas noted that the state statute does not define what proper cause means, and that courts had ruled that the standard was met by people who showed a special need for self-protection. This special need standard is demanding, Thomas wrote. For example, living or working in an area noted for criminal activity does not suffice. Ooh, that would seem to be a really good reason for me. In a concurring opinion, Justice Brett Kavanaugh noted that Thursday's ruling does not prohibit states from setting requirements to obtain a carry license, and that it addresses only the unusual discretionary licensing regimes. The case, New York State Rifle and Pistol Association Incorporated versus Bruen, was the first major gun rights case before the Supreme Court in more than a decade. In the majority opinion, Thomas referenced 2010's McDonald versus City of Chicago and 2008's DC versus Heller in his reasoning for Thursday's ruling. As we stated in Heller and repeated in McDonald, individual self-defense is the central component of the Second Amendment right, the justice cited. He also referenced, He also referenced how Heller made clear that restrictions on carrying guns in sensitive places is permissible, and how New York was wrong for arguing that its law was merely doing just that. We do think respondents err in their attempt to characterize New York's proper cause requirement as a sensitive place law, Thomas wrote, explaining that New York views sensitive places as anywhere where people typically congregate and where law enforcement and other public safety professionals are presumptively available. Now, see, that word presumptively is very important, because remember, New York cut the hell out of its police department. Remember that, the whole abolish the police while taking away your Second Amendment rights? Seems like a winning formula, doesn't it? This definition, Thomas said, is too broad. Put simply, there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place, simply because it is crowded and protected generally by the New York Police Department, he wrote. The conservative justice also looked at the plain language of the Second Amendment, which protects the right to keep and bear arms. He described keeping and bearing as two separate things, noting that Heller defines bear as to wear, bear, or carry. This implies public carrying, Thomas said, because someone would not generally wear their gun in a holster at home, but would keep it somewhere. The 63-page opinion also explored historical restrictions on carrying handguns that New York relied on. Thomas explained why they do not justify a current restriction, noting how past regulations from centuries ago focused on dangerous and unusual weapons. While handguns today are relatively commonplace, while the handgun may have been considered dangerous and unusual during colonial times, the opinion said, in modern times, it is the quintessential self-defense weapon. The court's opinion also stated the Second Amendment right to keep and bear arms should not be held to a lower standard than other constitutional rights. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. That is not how the First Amendment works when it comes to unpopular speech. It may soon if Nancy Pelosi and Kamala Harris get their way, or the free exercise of religion. It is not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it is not how the Second Amendment works when it comes to public carry for self-defense, Thomas wrote. Justice Stephen Breyer wrote an impassioned dissenting opinion in which he referenced present-day fervor over gun violence, as well as recent events. Joined by Justices Elena Kagan and Sonia Sotomayor, Breyer cited statistics including 44,222 Americans killed by firearms in the U.S. in 2020, the number of mass shootings that have already taken place in 2022, and how gun violence is now the leading cause of death for children and adolescents. The problem isn't the gun, the problem is crime. It's always in these blue cities. Many states have tried to address some of the dangers of gun violence, just described by passing laws that limit in various ways who may purchase, carry, or use firearms of different kinds. Breyer wrote, the court today severely burdens states' efforts to do so. Justice Samuel Alito, in a concurring opinion, took issue with Breyer's references to recent shootings. Does the dissent think that laws like New York's prevent or deter such atrocities? Will a person bent on carrying out a mass shooting be stopped if he knows that it is illegal to carry a handgun outside the home, Alito asked? And how does the dissent account for the fact that one of the mass shootings near the top of its list took place in Buffalo? The New York law at issue, in this case, obviously did not stop the perpetrator. Breyer recognized legitimate purposes for guns, such as sport, self-defense, or types of employment like security guards, but he said it's the responsibility of elected officials to balance these lawful uses against the dangers of firearms when crafting legislation. That consideration counsels modesty and restraint on the part of judges when they interpret and apply the Second Amendment. He said, no. It is not the job of any politician in any form or any way, if you're a law-abiding citizen, to restrict your God-given right. Remember, the Constitution doesn't grant you rights. It stops the government from interceding on those rights. The Constitution is clearly written with the mindset that these are your God-given rights, and no pansy waste in New York is going to take away my God-given rights. No person who has armed security around the clock is going to tell me I can't be armed. It's ridiculous. I just wanted to read you that. That is very big. It's going to affect a lot of places and a lot of things. I think that most of the country is moving towards constitutional carry, and give it 5 years, here's what you're going to see. As more and more states move towards constitutional carry, and these criminals realize, hey, in Texas and Florida, these people are walking around armed and they're not victims. California, New York, they're not armed. I can rob all day long. And plus, they're not going to charge me anyway. Plus, they're not even going to charge me with a gun crime if I get caught. So why not go there and commit my crimes, which is probably what's going to happen. You people be safe if you stay in one of these blue states. If you can't get out, I know it's terribly expensive. I just wanted to put that out there, though. It came through this morning. This is very important for all the Second Amendment enthusiasts. I have later on today, hopefully, I can get back around to it. If not, it'll be tomorrow morning. Article in which Kevin Sona is quoted. It's coming right out of Thailand. And another nice article from another big Second Amendment leader. So like, subscribe, share, as always, especially in these days and times, with the help of the Supreme Court. Keep your powder dry. Do what you got to do.